welcome everyone to the Environment Primer series of Drishti IAS. My name is Pragya and today we are going to discuss a significant and an important topic that is important from not only your prelims perspective but also for your mains point of view. The title of our today's discussion is Implementation Issues in the Forest Rights Act 2006. In this discussion, we'll firstly see the intent with which this act was enacted. Then we are also going to see the historical injustices that has been done to the forest dwelling scheduled tribe communities as well as the other traditional forest dwellers. Okay. Then we are also going to analyze the importance of this act. Then we are also going to analyze the issues in its implementation. And in the end, we are going to see a practice question for your prelims examination and a practice question for your mains examination. So if I talk about the background of our today's topic, you all know that this Forest Rights Act was enacted so as to protect the rights of the scheduled tribal communities that used to dwell in the forest and that is dwelling in the forest and other traditional forest dwell community. And this was a socio-environmental watershed legislation in terms of forest governance. Okay, but what has happened is that this act is not being properly implemented. In fact, after the enactment of the Forest Conservation Amendment Act of 2023. So, after the enactment of this Forest Conservation Amendment Act of 2023, what the central government is proposing? It is proposing to decrease the forest lands. It is proposing to convert the forest land into the non-forest land. And definitely this has stirred a controversy. In fact, the National Scheduled Tribes Commission is also involved in the issue now. Okay, apart from the Supreme Court. So definitely this has again brought this topic in the limelight. So this brings us to the moot question of our today's discussion, that what was the intent which this act was enacted by the parliament. Okay, so the FRA enacted in 2006 recognizes the rights of forest dwelling tribal communities and other traditional forest dwellers, also known as the OTFDs. Okay, so they are known as OTFDs, to forest resources on which these communities were dependent for a variety of needs such as livelihood, such as food security and other such their daily based needs. They were highly dependent on the forests, but there were injustice to their rights in the post-colonial era as well as after the independence also, and that is why this watershed legislation was enacted by the parliament so as to conserve their forest management rights. But sadly, this act lacks implementation, or there is a political will, lack of political will to implement this act. So, this was the intent of the act, to promote forest governance, to effectively manage the forest as well as to grant them forest management rights. But sadly, this is not happening as of now, and we will be discussing the historical injustices done to them in our further slides. Okay, so the intent is clear to you all that the intent was to secure these communities their rightful rights in the forest. Okay, moving forward, the Forest Rights Act or the FRA attempts to put an end to the long drawn conflict over supposed forest encroachments. Okay, so this is the dichotomy. On one hand, you are trying to create carbon sinks. We have been discussing in our environment primer episodes that yes, we need to have natural carbon sinks in the form of forest so as to absorb the carbon dioxide from atmosphere. But if you talk about forest, definitely they are encroached for development purposes, and definitely the India's forests have sunk dramatically. So this is an issue as of now. So this legislation wanted to put an end to the conflict between the scheduled tribal forest dwellers as well as other traditional forest dwellers communities and the government of India. Okay, so this was a landmark legislation, a watershed legislation in terms of forest governance. Simultaneously, it seeks to create a much more democratic bottom-up forest governance, and this is what I am explaining to you. The Act had 4 objectives. Objective number 1, to ensure the undo of historical injustices done to the scheduled tribes, forest dweller communities as well as the OTFDs. Then to conserve the forest, to conserve the forests. Then your objective number 3 is to ensure proper forest management rights for the livelihood, food security, and other needs of the ST communities, ST forest dwellers communities as well as the OTFDs. Then it also had an objective of giving them more authority, more responsibilities in the forest management rights, so as to ensure that there is conservation of forest, there is maintenance of ecological balance as well as the sustainable use of the forest. So these were the main objectives behind the enactment of this Forest Rights Act. Now let us talk about the historical injustice that has been done to the scheduled tribes, forest dweller community as well as the OTFDs. Okay, the scheduled tribes have long been in symbiotic relationship with forests. They are not like us modern people. They are very, attached to the forest, attached to the natural things. So they form a symbiotic relationship with forest. They are very attached to the forests. Okay. The forest policies in both colonial and post-colonial India did not recognize the symbiotic relationship of the STs with the forest. So this issue was there also in the pre-colonial era and as well as in the post-colonial era. Post-independence also we have imposed certain things on this community without recognizing their traditional rights. Prior to the colonialism, local communities enjoy customary rights over forest in their vicinity or even a large region. So the kings had their hunting rights, but yes, the effective control of the forests were in the hands of the scheduled tribes residing in the forest as well as the other traditional forest dweller community. So what happened was, the colonial takeover of India's forest, however, resulted in a massive disruption of these traditions because the Britishers were only interested in exploiting India as much as they can. So they started exploiting our forests as well. So what did they do? They based on the false idea of eminent domain, that the ruler always owns all of the property. They enacted in 1878 the Indian Forest Act, and the takeover of India's forest began. In fact, after the enactment of this act, Indian Forest Act or the Imperial Forest Act, okay, certain things happened. Certain injustices were done to these communities. So the first injustice done was that they lost control over the forest. They lost control over the forests. So the communities which had the traditional rights over forest, they completely lost the control over the forest. In fact, forests were treated as timber resources. And shifting cultivation was banned. Shifting cultivation was banned. Okay, so firstly the Britishers banned the shifting cultivation. They only utilized the forest for timber resources, or they utilized the forest for their own benefit, for their own economical benefit. Then what happened was, the communities lost their concessional privileges. lost their concessions. Their So the concessions that were given to these tribal communities were lost. They were treated as a privilege. So what do we mean by treating as the concessions as privileges? That means that the privileges could be withdrawn anytime. And now they were dependent on the forest bureaucracy. Okay. So these communities were not dependent on the forest bureaucracy. They completely lost the access to their own forest. The access were either limited, chargeable, or they were simply denying them the access of the forest. Okay. So these were some of the historical injustices done by the Britishers to the rights of these traditional communities. And there are other historical injustices as well. For example, they also, treated the local communities as trespassers. They were not giving them the accesses, and we have discussed that they lost all their concessions. They were treated as privileges, and they could be withdrawn at the will and the power of the forest bureaucracy. So these were some of the historical injustices done to the tribal communities. They lost their own rights over the forest, and this continued to be there post independence as well. So what happened when India got independence? Let us understand. So when India got independence, the forests were still treated as a state property. Okay, so the Indian government also relied on the doctrine of eminent domain, that forests were completely their property. Okay, then leasing of forest lands. Leasing of forest lands for agriculture. For agriculture. So the government also, leased the forest land out for the agriculture under the Grow More Food campaign. So this also happened. In fact, the ST communities, STs and the OTFDs, who were legitimate cultivators of the forest lands, were treated as encroachers or trespassers, and this happened post independence as well. In fact, the environmental legislation such as the Wildlife Protection Act, the Wildlife Protection Act of 1972 and the Forest Conservation Act of 1980 were also based on the doctrine of eminent domain. So these injustices continued post independence as well. They were already facing historical injustices during the colonial period, as I have explained to you in my previous slide, and these historical injustices were continued post independence as well. That means our forests were exploited by the Britishers as well as the Indian government. The only difference being that the Indian government was exploiting the forest resources in the name of the national interest. Moving forward, the Imperial Forest Department was established to harvest and transform the forest to maximize timber. And that is why I said that the forests were being treated as a timber resources, and the shifting cultivation was banned, and revenue and was also tasked with protecting state property against local communities now deemed trespassers. So this is talking about the colonial era, that what did the Britishers do, and we have discussed this in detail. I have explained to you that what exactly happened. Okay, so there were worsening of matters post independence as well, and I have explained to you what happened post independence, that same things used to continue but in the name of national interest. Moving forward, lakhs of communities were forcibly resettled when creating sanctuaries and national parks. For dams also they do the same thing. They displace the communities for making hydroelectric power projects and dams, but they do not give an another accommodation to them, alternate accommodation to them, and hence they encroach upon their forest land. And in diverting forest for development projects, neither were the views or the consent of the local communities taken into consideration, nor, in spite of imposing hefty net present value fees on the project were the local communities compensated for the impact on their livelihoods. So there has to be a community consent. Community consent principle is there. Community consent principle. That means you will take the consent of the community before utilizing the forest land for development projects, but this does not happen. In fact, the communities who are displaced from the forest are not given any alternative solution by the government, and neither they are provided any monetary compensation for the loss of their livelihood. And in fact, they are trying to bypass this community consent also by help of the Forest Conservation Amendment Act of 2023. Okay, moving forward, let us understand what was the importance of the FRA 2006. So the Forest Right Act recognizes the rights of the forest dwelling tribal communities and other traditional forest dwellers, as I have explained to you. Then it provides the right of forest resources on which these communities were dependent for a variety of needs, including livelihood, habitation and other socio-cultural needs. In fact, it recognized various rights such as the title rights, uses rights, rehabilitation rights, and forest management rights. Forest management rights of these communities. So basically, it tried to undo the historical injustice that have been caused to these communities, and that is why it gave 4 important rights to these communities. That is the title rights, uses of the forest rights, then rehabilitation rights if they are illegally displaced, and the forest management rights. In fact, it also talks about individual forest rights or IFRs and the principle of community consent. Okay. The act encompasses right of self-cultivation and habitation, which are usually regarded as the individual rights. So these are known as the IFR or the individual forest rights. Okay. The Gram Sabha is also a highly empowered body under the act. The act enjoins the responsibility of conservation and protection of biodiversity upon the Gram Sabha and the right holders. Who are these right holders? Who have individual forest rights, but these also are poorly implemented. There is clear cut a lack of political will to implement these rights, and we'll be studying the issues in implementation in our further slides. Okay. So the Gram Sabha shall be the authority to initiate the process for determining the nature and extent of the individual or community forest rights. So as you can see, the Gram Sabha is a very important body under the Forest Right Act of 2006, because the local community will only understand the local needs. The government is not going to understand the local customs of the tribal people, etc. And that is why the Gram Sabha was empowered to as a important body under the for the conservation of the forest rights under the Forest Rights Act. Okay, moving forward, let us understand that what are the issues in the implementation. So first issue is there is a clear cut of lack of political will. The legislators or the politicians only do not want the act to be implemented. The politicians in most states focus solely on individual rights and projected the act as an encroachment regularization scheme. So the government is arguing that these communities, the ST forest dwell communities as well as the other traditional forest dwellers, are encroaching upon the forest, which is the state property. Some even encouraged illegal new cultivation in a few pockets. So for development schemes, definitely the corporates are dependent on the cheap natural resources, and for the development scheme only they considered this act is only to be projected as only encroachment removal scheme. The act was never recognized as a Forest Governance Act. It was recognized as a encroachment removal scheme. Claimants were put through enormous hardship during claim filing, subjected to faulty and non-transparent rejections and arbitrary partial recognition, even if the individual forest rights are recognized. So we were discussing that the act has recognized the individual forest rights, but go and claim them. You will find what is happening. There are clear-cut issues. For example, if the claimants are going to claim to the rightful authority that yes, our individual forest rights have been violated, they are subjected to very arbitrary things, and definitely it is very difficult to claim that your individual forest rights has been violated. In fact, the Forest Conservation Amendment Act of 2023 completely tries to undermine the individual forest rights. It can, in fact, it talks about converting a forest land into a non-forest land, and this can happen with those forests also which come into the reserved category forest. So imagine what is happening, that completely it is trying to undermine the individual forest rights, although it talks about the individual forest rights, but how far it will be implemented is still a question, because the Forest Right Act 2006 is already facing the implementation issues. Okay. The biggest lacuna in the FRA implementation is the extremely slow and incomplete recognition of the community rights to access and manage the forests. So this is what I am explaining to you, that they are completely undermining the community consent, the community rights, the traditional rights of these community to manage the natural resources of the forest on their own. Now it completely is the prerogative of the central government. Maharashtra, Odisha and more recently Chhattisgarh are the only states to recognize community forest rights substantially. But if you talk about Maharashtra, there is this very famous forest known as the ARAI in Pune. The government suggested that yes, remove the ARAI forest cover and use it for development purposes. So this happened in Maharashtra, but after vehement protests, the Maharashtra government had to bow down in front of the forest right activists. So no state government as well as the central government is planning to conserve the forest for development purposes. They are in fact planning to utilize the forest land for development purposes, and that is why they lack in the effective implementation of these environmental legislations. If you talk about the Forest Right Act 2006, it is completely dependent on technological know-how. It is completely dependent on the digital platform. But do you think the tribal people have digital knowledge, or they have the app that is required to file the claims? No. So why are you using the technology? Just to delay the implementation. Okay, so these are the issues in the implementation of the Forest Rights Act of 2006, and these issues will further crop up when the power is given to the central government to convert the forest land into the non-forest land. But as of now, this Forest Conservation Amendment Act of 2023 is challenged in the Supreme Court. So these were the major issues in the implementation of the Forest Rights Act of 2006. So with this, we come to a conclusion of our today's discussion. We have seen that what was the intent behind the act, what was the objective of the act. Then we have also seen that what are the importance of this act, what was the importance of this act. Then we have also analyzed that what are the major issues in its implementation, and we have also seen that how the government is planning to divert the forest land as a non-forest land for development purposes, and what are the pressing issues. Okay, so there are challenges in its implementation. The previous act also had challenges, and definitely the new act will face certain more protests, more restraint from the forest dweller community or the other traditional forest dwellers community. In fact, the National Commission for Scheduled Tribe is now involved before the Supreme Court by invoking its constitutional power. Now let us discuss the practice question for your prelims examination. So the question is, under the Scheduled Tribes and Other Traditional Forest Dwellers Recognition of Forest Rights Act 2006, aka the FRA of 2006, who shall be the authority to initiate the process for determining the nature and extent of individual or community forest rights, or both? And this is a PYQ asked in the year 2013. So options are, option A is State Forest Department, option B is District Collector or Deputy Commissioner, your option C is Tehsildar or the Block Officer or the Mandal Revenue Officer, and your option number D is Gram Sabha Kindly drop your answers in the comment box below. Now let us analyze a practice question for your mains examination. So the question is, examine the status of forest resources of India and its resulted impact on climate change. And this is also a PYQ which was asked in the year 2020. So firstly, you will write about the forest resources in India, the forest cover in India, and how it is depleting slowly. Then you will write that yes, there are legislations, but there is a lack of implementation. On one hand, you are saying that we need to create natural carbon sinks in the form of forest. We need to increase afforestation. We need to prevent deforestation. On the other hand, you are not implementing the watershed legislation, social environmental legislations. And you can conclude holistically that yes, the consent of the community that is completely dependent on the forest should be involved while converting a forest land into a non-forest land for development purposes. Okay, so you can conclude very holistically. I hope this session was insightful for you. If you have any feedback regarding the session, kindly drop it in the comment box below. If you liked today's discussion and found it to be helpful, kindly like the video and subscribe to our channel for more such updates. Thank you.